Good afternoon, and thank you for joining us today for an MP webinar on the hazards of return to work, legal risk, COVID vaccination policies, and common employer lawsuits. I'm Amy Lehman, Head of Marketing here at MP. And for those of you joining us on a webinar for the first time, MP is a full-service human capital management company offering a suite of products and services, including HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR, and we help our clients succeed by aligning their HR strategy with their business goals. I'm thrilled to introduce your presenter today, attorney Mark Ventola from Sheehan Phinney Law Firm. Mark is the co-chair of the firm's Labor and Employment Law Practice Group. He provides focused, practical advice about the many aspects of the relationship between employer and employee with an eye towards risk management and claims avoidance. He also develops agreements, policies, and protocols concerning hiring, trade secrets, termination and separation, wage and hour, family and medical leave, employment discrimination, and non-compete and other compliance issues. He frequently works with executives negotiating and drafting agreements and compensation arrangements, both at the initial and terminal points of employment. A little bit about Sheehan Phinney. As one of the premier full-service business law firms in New England, Sheehan Phinney provides a broad range of sophisticated legal services to clients in traditional and emerging areas of law. With approximately 60 attorneys and a talented and diverse support team, Sheehan Phinney represents clients throughout the New England region, nationally and internationally. Many of their attorneys have been named among the best in their field by Chambers USA, Woodward White, and Martindale Hubbell. In the most recent Chambers USA publication, Sheehan Phinney is the only New Hampshire-based law firm to be ranked in the top tier for every listed area of law. The firm is also a member of the prestigious Le Mundi, the world's leading association of independent law firms, an esteemed mark of excellence for legal services within the international community. Additionally, Sheehan Phinney Capital Group offers government relations and legislative lobbying services to clients throughout New England and Washington, D.C. For more information, you can visit the firm's website. Just a quick disclaimer, this training is intended for educational purposes and informational purposes, but should not be construed as specific legal advice. A recording of the webinar will be sent out later today along with the slides. And if you have any questions during the presentation, feel free to submit them in the Q&A. And with that, I'm going to hand the mic off to Mark.
Thanks, Amy, and welcome everyone. We are going to spend the next half an hour or 45 minutes talking about a few of the most important issues that are very timely with respect to return to work in light of COVID. What we're going to cover are the following topics. Of course, vaccination issues, and we're going to cover them from the perspective of both what happened most recently last week in terms of the presidential announcement about vaccination, and also from the perspective of what was in place and what existed and what did we know about vaccines and vaccine mandates before that time. Talk a little bit about vaccination policies, talk about return to work and travel for employees that need to travel as part of their job. We'll talk also about some litigation that has taken place to date, and especially in light of the risks that the type of litigation that has happened to date might pose for your organization. And then we'll talk also about some legislation that's pending around the country. Next slide, please. So with the Delta variant and other variants that have arisen in the past few months, states have really, as we all know, responded by rolling back what had become more relaxed standards for dealing with COVID. And while we still see, and while we've seen vaccination numbers increase recently, it had up until recently plateaued. So what's going on with respect to vaccination? Well, most employers, most businesses do not want to return, and I don't think government either wants to return to a shutdown mode. So employers have, over the last 2, 3, 4 months, been asking, can we mandate our employees to be vaccinated? And the answer to that question was pretty clear. And in my mind, it remains clear. But there was always an open question, and we'll take the next slide, about whether whether the federal government can mandate a vaccine. Next slide, please. So can the federal government mandate that employees and that members of the general population be vaccinated? Very interesting question. We, as lawyers, have had our views about that for quite some time. We can look at the next slide now, Amy. And that our views were, up until last week, I think, that the government would not, from a federal perspective, be able to mandate that employers impose vaccine requirements on their employees. Well, the world has changed a bit, as we know. The presidential mandate came down last week. The president has directed OSHA to issue what's referred to as an emergency temporary standard that will require employers, private employers with 100 or more employees, to do one of two things: either mandate that employees receive a vaccine, or for employees who don't receive a vaccine, that they produce on a weekly basis a negative COVID test. So that's the basic standard. An emergency temporary standard is something that, and I think we've all in the last 18 months come to know things about the law, about government, and about regulation that we never before had any reason to deal with. But an emergency temporary standard is something that OSHA, the Occupational Safety and Health Administration, can issue if it determines that there is some grave danger presented to employees, and that a standard or regulation or rule must therefore be put forth. So the president has directed OSHA to issue this emergency temporary standard. Now, as part of it, we know that employees who are directed to be vaccinated must be given paid time off to be vaccinated. We think, but we're not sure, that they would be given time that is compensable to test. That's something that will be coming forth in the emergency temporary standard regulation. And what we don't know about the paid time off that employers need to provide is whether that time will somehow be reimbursed by the federal government, as other paid time off during COVID has been reimbursed. So we'll look to the regulations to see if that is something that is addressed. So again, we know some things, we know a broad outline. We do not know the answers to many of the questions that employers will have. But there are a couple of things that I can say about this, and things to keep in mind, at least at this point. The first is try to figure out as best you can whether this emergency temporary standard is going to apply to your workplace. Some of you may be asking, well, we have not 100 people in one location. We have 50 in one location, 40 in another location, and 30 in a third location. From what I've read so far, it will be, the 100 number will be viewed from the perspective of adding up all of those separate locations. Again, we won't know for sure, but from what I've read, that's what it will look like. Think about, in the context of getting ready, if these standards apply to you. And frankly, even if you're confident they do not, and I suspect that many employers on the webinar are smaller employers who have fewer than 100 employees, but even if they do not, whether you would like to look at these emergency temporary standards as a model or guide as to how to deal with your workplace for those of you who are still considering these kind of things. So think about how you would deal with remote workers for purposes of vaccination or testing. Think about how you're going to identify, to the extent you have not already, vaccinated and unvaccinated employees, and how to obtain that information, and then how to keep it and keep it securely, and think about who would then have access to it. Think about whether you will require or sponsor on-site vaccination clinics, or perhaps partner with other local employers to provide on-site, simple, easy vaccination opportunities. Think about whether and how to provide paid time off for vaccine. And it's not just to obtain the vaccine. One of the things that the emergency temporary standard will say, we know this much, is that the time off will be, yes, to obtain the vaccine, but also to recover from any side effects of vaccination. And I think we all know, we've either experienced ourselves or we know people who have experienced some side effects from obtaining the vaccine. So think about all those things in terms of looking at this emergency temporary standard. Lastly, I'm going to say on this topic of the emergency temporary standard before moving on, is that while the president says and OSHA says that these standards will be coming out within a couple of weeks, we also know that there are legal challenges that already are being mounted. And it would not at all be surprising if, as a result of one or more of these legal challenges, a federal court somewhere in the country issues an injunction, meaning a stay, an order saying that these standards cannot be implemented until there is further court action. So there may well be delay. These standards, once they come out, may well not be implemented immediately, but we should all stay tuned and keep this right on the radar screen. So next slide, please. So up until now, when thinking about the vaccine mandate, there really has been no precedent, if you will, for the federal government mandating on a nationwide basis vaccination. Different states have done it from time to time and have mandated vaccines in certain situations, but the federal government itself has never done that. The president acknowledged that, and I mean, you see the news clips where, 6-8 months ago, a year ago, the thought of mandating a vaccine was not on people's mind, and in fact, the exact opposite was being thought. So the EEOC, however, has always said that a vaccine may be necessary for some particular types of jobs, but there always has to be, and we'll get into this a little more, exceptions or opportunities to opt out for medical or disability reasons, or also to accommodate some religious beliefs. Next slide, please. So thinking back, it was only on December 11th of last year, so not even a year ago, that the FDA issued the first emergency use authorization for the Pfizer vaccine. And one of the things that the FDA requires when it issues an emergency use authorization is that any patient who is going to receive the vaccine be informed that they have the option to accept or refuse that vaccine. I'm going to come back to that later in the slides when we talk about litigation, but the idea that I want to get across on this point is that that particular warning or information that a patient has the option to accept or refuse is really just applying in the medical context, right? I have the option to accept or refuse this vaccine, and I need to be warned about that just before I'm going to receive the vaccine. That does not, however, mean, and the emergency use authorization does not address any employment consequences for a refusal to accept the vaccine. And this option, if you will, to accept or refuse the vaccine does not apply in an employer mandate situation. So something that's really important to understand here. Next slide, please. So the EEOC has always said and consistently said that any vaccine mandates need to be job related, consistent with some business necessity. Think about, for those of you who either work in the healthcare field or if you have employees who are sent into healthcare environments, employees who are sent into hospitals or doctors' offices on a regular basis. For years, hospitals have had a mandate that any vendors who send employees onto their sites each year have to demonstrate proof of flu shots and MMR vaccines and other vaccines. So that's an example where the EEOC has looked at the job requirements and whether a vaccine mandate of that type is job related and consistent with business necessity, and has determined that yes, it is. So that notion of vaccination, the flu shots, MMR, other vaccinations being mandatory for work has been around for quite some time. Next slide, please. So the EEOC's guidance on vaccinations has made it clear also that if an employee refuses to get the vaccine based on a medical or religious reason, reasonable accommodations need to be made or should be considered. So the basic idea here is, yes, employers are allowed to mandate that employees receive the vaccine, but in doing so, they need to recognize that exceptions must be made and reasonable accommodations must be considered for employees who present medical reasons or religious reasons why they could not receive a vaccine. Next slide, please. So reasonable accommodations exist based on both Title VII, which is the federal law about disabilities and religious rights. And they also exist based upon state law protections for disability and religious rights. Next slide, please. Now, when you're addressing issues associated with requests to be exempt from a vaccination mandate, and the request to be exempt is based on religious belief, you have to, it's not just any religious belief. This has to be a sincerely held religious belief. Anything that's non-religious in terms of opposition to the vaccine is not sufficient. And so it must be something where the employee can describe for the employer with sufficient certainty why it is and how it is that their particular religion is one where a vaccine would not be allowed. Okay, how much information can be requested? That is enough to satisfy you as an employer that the request is something that is sincere and that it is certainly firmly held by the employee, and it's something that is clearly established in this particular religious belief. Next slide, please. So an employer being presented with a request for a religious accommodation needs to recognize that and to reasonably accommodate it, unless doing so would result in some kind of an undue hardship to the employer. Okay, undue hardship, you've probably seen this concept when dealing with disability claims and requests for medical accommodations. The concept of undue hardship exists there as well. In the religious accommodation arena, it's a bit less stringent when we're looking at what is an undue hardship. It has to be something that presents more than a minimal burden on the operation of the business, which that's the standard. That's a much easier standard to meet than the standard that's presented for purposes of disability. Next slide, please. Okay. If as an employer, you're presented with a request to be exempt from a vaccination mandate based upon a disability or for a medical reason, you're in that similar mode where, like the ADA, you have to make some inquiry and determine, is this disability or medical condition recognized? Is it truly a physical or mental impairment that would prevent this employee from receiving the vaccine? In the course of doing that, assuming you determine that there is in fact a legitimate disability, the employer is then obligated to engage in an interactive process like under the Americans with Disabilities Act, engage in an interactive process to discuss what could or could not be reasonable accommodations for the employee. Now, one thing to make clear is that a reasonable accommodation does not exist if the request is one that would present a direct threat to unvaccinated employees in the workplace. A direct threat is a concept that runs through the EEOC regulations and guidance on vaccinations, and an employer is not obligated to make an accommodation or to allow an exemption from vaccination if doing so would present a direct threat to other workers in the workplace. Next slide, please. The direct threat analysis looks at four things. They're shown on this slide. You look at the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm might occur, and the imminence of that potential harm. So we're looking at and taking into account things like, what is the work environment? In the area where the request is being made, what is the level of community spread? Is it high? Is it low? What is the general vaccination rate in your workplace? If the vaccination rate, for example, is 98%, and you're being asked by one of the 2% to not be vaccinated, that is certainly something, the vaccination level and percentage is something to take into account. The other thing to keep in mind is the frequency of the contact between and amongst coworkers. How often does this person who is requesting an exemption from the vaccination requirement interacting with other coworkers? So all of those things are taken into account when looking at and considering the direct threat analysis. Next slide, please. So if, as an employer, you're running through this analysis and you determine that the unvaccinated worker poses a direct threat, you can't exclude that person from the workplace unless there's no way to provide that reasonable accommodation that would either eliminate or reduce the risk of the threat. For example, could you put this employee in his or her own workspace, closed off from all others in the workplace? If that's something that you could do, and it's a reasonable accommodation to do it because there is an empty office, say, that no one is using, and this worker could be there more or less all day, that would be a reasonable accommodation that would reduce the risk. If you can't do something like that, you have a direct threat, and there is no way to make a reasonable accommodation that doesn't present an undue hardship, that would be the point at which you'd be looking at things like termination or layoff or extended leave for that particular employee. Next slide, please. Now, some of you may have unions here, and we're seeing this a little bit more now with the emergency temporary standard. Unions are taking a position on this. Most are in favor of vaccinations to provide a safe workplace for all of their workers. But even with a mandate, and even with the presidential mandate or with an employer mandate, there will, in most cases, need to be some type of bargaining with the labor union in order to effectively institute the mandate. Typically, the employer will, typically, not always, but typically under the management rights clause of a collective bargaining agreement, an employer will be allowed to make the decision to vaccinate and to mandate vaccination. But the employer will also have an obligation to bargain about the impacts of that decision and to reach conclusion in that bargaining before the mandate is actually instituted. Next slide, please. If as an employer you decide not to mandate vaccination, can you provide incentives to do so? Yes. The answer is yes, and that's been fairly clear from the beginning. Employers are free to provide incentives. The only question that has come up, and I've never seen it be a problem, it's just more a theoretical question, is whether those who have a religious or a medical exemption and thus are not able to get the vaccine should be given similar incentive. Again, just a theoretical question at this point. Alternatives to vaccination. So obviously these things could include many of the things we've been looking at from day one of COVID: moving employees to a new job or a different workspace, testing on a more or less regular basis, remote work, at least for a period of time, PPE and different forms of PPE, instituting furloughs or leaves for some people. All of these are alternatives that can be explored for any one person who will not get the vaccine, and or if an employer decides that they are not going to mandate the vaccine. Termination, as I've said, should be the last option, only when an unvaccinated employee represents a direct threat to others, and there's no possible reasonable accommodation that can be made for that person. Next slide. The one thing we want to make sure of as we're going through this and as you're developing policies and also as you're dealing with individuals is that consistency be paramount. Employers really need to be consistent with respect to how these mandates or these decisions are made so that people in similar situations are treated similarly. Next slide. So we're going to move on just to the next topic and talk about travel a little bit. We'll do this quickly, but just to think about this from a background perspective, it was not even 2 years ago, the end of January, where the first travel ban was put into place for non-US citizens traveling from China. Between February and May of 2020, travel was limited between a number of other countries. Next slide, please. The list of countries seems to change daily, or seemed to for quite a while. International travel, as we know, was really taboo for quite a while. And we can even think, as you know, this now is probably ancient history, and you know, ancient history in this context is really 6 months ago. Thinking about 2 years ago seems to be like when the dinosaurs roamed the earth. But there were times when people were asking questions: can I drive my car across the border from Massachusetts to New Hampshire? Or can I drive from Massachusetts into Maine or Vermont or Rhode Island? Those things are not now issues for us, the interstate travel. But at one point they were. Next slide, please. We do know that business travel slowly increased last summer and then through this summer, but the Delta variant has really come along and reversed many of the gains we had made with respect to travel, and especially interstate and international travel. Next slide, please. May of this year, August of this year, countries began opening to travelers with proof of vaccination or with proof of testing. We just recently, Canada opened its borders, the UK opened its borders, and over the summer, people were traveling again to many places in Europe. Next slide, please. Right now, the CDC has just recently, just on August 25, updated its guidance about travel. And I would encourage all of you to look at that to the extent that you need to deal with travel for your employees. I would encourage all of you to look at it. The breakdown, of course, and it's only logical, is there are different types of restrictions and recommendations based upon whether the travel that's needed is domestic or international, and also based upon whether the traveler is vaccinated or not vaccinated. So again, to the extent you have employees who need to travel, I would strongly recommend you look at the CDC website on that point. Next slide, please. OSHA has a few things to say about travel as well. And when you think about OSHA, the general point to keep in mind with respect to COVID is that employers have a duty under what is referred to as the general duty clause, have a duty to keep their workers safe. And that's obviously a very broad duty that can be thought about and considered from many perspectives. So from the perspective of employees who have as part of their job a requirement of travel, how does an employer keep those employees safe? Certainly by following the CDC guidance on travel. That's a start. Certainly by thinking about whether travel is actually necessary. Next slide, please. So a couple of things to consider. We probably all have. Is travel really necessary? And can the task be accomplished by remote meetings, right? Should we mandate, even if we're not broadly mandating vaccines for our employees, should we mandate that employees who have a need to travel more or less frequently be vaccinated before they be allowed to travel on business? Certainly, it's a time, if you haven't already, to update any policies that you have about travel and about conduct during travel, and looking at and thinking about the common requirements, masking, whether you're using indoor dining or outdoor dining, whether you're allowing employees to use rideshare applications, things like that. Also, whether, if you aren't going to mandate vaccination for travelers, whether the rules will be different for those who are vaccinated and those who are not vaccinated. Lastly, I'd just say, I think we all recognize this concept of pandemic fatigue. We're all experiencing it more or less to some degree. And employees are not at this point, and we're seeing this all the time, as ready and as willing to accept guidelines as they once were. So that should all be kept in mind with respect to employees who travel. Next slide, please. Next slide, please. Okay. We suggest that at a first cut, you decide whether travel is necessary, of course, and that in doing so, job descriptions be updated so that They include if travel is necessary. Usually that is in the job description, but make sure that travel is included. And think about it from the perspective of whether travel is one of the essential duties of the job. And we say that because the concept of essential duties ties into the whole disability request for accommodation standard. Minimize non-essential business travel and ensure that proper accommodations are discussed in light of vaccination status. And if employees are not traveling or are not allowed to travel and it's due to the inability to be vaccinated, that there be no retaliation as a result of the inability to travel. Next slide, please. All right. So now I just want to talk for a few minutes about some of the cases that we've seen. And the first couple of cases, the Bridges case and the Clausen case, both deal with vaccination issues. They deal with them in different contexts. The Bridges case was one of the first cases brought by healthcare workers against the Houston Methodist Hospital, which had instituted a mandatory vaccination policy. The argument presented at the time by the workers was that the vaccine was experimental and that they should not be required to essentially be human guinea pigs for the vaccination. The court did not accept that, clearly. Court didn't accept the argument, but it's been made and it is continuing to be made. There was a case filed just 2 or 3 days ago against another hospital, a hospital in Kentucky, and that argument, among others, is again being made. The court is saying, court in Bridges said, and I expect the court in this case in Kentucky to say that it is certainly fine to require, and for an employer to require in a healthcare setting their employees to be vaccinated, subject to the requirement that we've discussed that there be religious exceptions and disability or medical exceptions made to the vaccination requirement. The second case, the Clausen case, came up, also a vaccination case, came up in a bit of a different context. Many of us have had to deal with the requirement of children going back to college and the college or university requiring students to be vaccinated as a condition of coming back to school. The University of Indiana was sued, had such a policy and was sued. The district court, the federal district court that heard the case, upheld the mandatory vaccination requirement. And then the Seventh Circuit Court of Appeals, which is the highest level you can go in the federal system other than the United States Supreme Court, also upheld that vaccination requirement, saying that and citing a case that was brought in Massachusetts back in 1905 dealing with the smallpox vaccine, and saying that the vaccination requirement for students to attend the university is fine, that there is historical precedent for it, and that in fact the students have choices. And the court looked at it from the perspective of the student having the choice of attending or not. The vaccine mandate is there if you wish to attend, but the choice to attend is the students. And there are colleges and universities that do not have a similar requirement. So from the court's perspective, there is sufficient choice and no one is being forced to have the vaccine. So the arguments that were made, as I said, was this human trial, that it's an experimental and dangerous situation, that this is only an emergency use authorization, although we know that the Pfizer vaccine has gotten beyond that at this point, but that it was only an emergency use authorization, and that to force employees to make the choice, at least with respect to the Houston Methodist Hospital case, to force the employees to make the choice of being vaccinated or not, really put them in a situation of being wrongfully terminated. The courts have rejected all of those arguments to date. Next slide, please. So in particular industries, what we're seeing, the industries we're seeing the litigation in are the ones that really have been sort of front and center and have had to keep working during the pandemic. The healthcare industry, the retail industry, manufacturing. That's where we've seen the bulk of the cases, although it's not exclusive. And the types of claims we're seeing are about employees requesting leave and remote work as accommodations. Primarily, we see the cases when those are not granted. We're seeing cases about retaliation, employees claiming they're being retaliated against for perhaps making complaints to OSHA or departments of health about their work environment. We're seeing discrimination claims. We're seeing wage and hour cases, primarily based upon remote work and the challenges that remote work presents in terms of keeping good track of work hours and the challenge that an employer has of knowing whether an employee is on work time and working or not. We see cases about the workplace being unsafe, and we've seen now some cases about emergency paid sick leave under the Family First Coronavirus Relief Act. Okay, we're also seeing, and that's fine, we'll stay with this slide, but just so you know, many of these claims we're seeing are against smaller employers. And I think the reason for that is that smaller employers have fewer resources to keep track of all the requirements that they're being presented with and all of the different challenges that they're seeing. And most smaller employers are having a difficult enough time just keeping business going, as opposed to trying to stay on top of all of the different COVID requirements. Now, if you've laid people off and you're thinking about rehiring, one thing to look at is whether the layoff initially was described as temporary or permanent. If it was described as temporary, the former employees really need to be brought back rather than first hiring from outside. If the layoff was described as permanent, then new employees rather than the ones who were laid off could be brought. It's safer to bring in employees from the outside. Same goes for the rehire terms. Should they be the same or should they be different? If there are going to be changes, they should be carefully documented. And it is always safer to make any changes to employment terms, and I'm thinking of wage or salary changes, if the layoff was designated as being permanent rather than temporary. Okay. What we've seen here is a couple of lawsuits involving the rehire of only the younger, less expensive, lower paid employees. So just a couple of thoughts there on rehiring. Next slide, please. The last thing I want to just touch on briefly is legislation. There is legislation pending in many states that would do the following, and it's been pending for a while. One would be to prohibit vaccine mandates. Now, what would happen and what will happen if one of those pieces of legislation in the state passes, and how that would collide with the new presidential mandate on vaccination for employees of employers of over 100. Your guess is as good as mine at this point, but there has been legislation pending in a number of states that would prohibit vaccine mandates. There's also legislation pending in a number of states that would prohibit businesses from requiring customers to provide vaccine documentation. There is one state that I'm aware of whereby governor's order that has actually become, I guess I would describe it as the law. It's an executive order in the state where a governor has mandated that businesses cannot require customers to provide vaccine documentation. There's also legislation pending in some states where employers would be prohibited from mandating the disclosure of their vaccination status. But again, that has not passed anywhere yet, to my knowledge. It's just pending legislation, but it is something that we should all be aware of and continue to monitor. So that covers my presentation for right now. I think there are probably a few questions out there, and maybe we'll try to answer a couple in the time that we have left. So Amy, maybe we could take a look at the questions.
Sure. So we have a question. Doesn't the presidential mandate also include employers who receive funding from Medicare and Medicaid?
That is correct. It includes those employers in the healthcare sector that receive any funding from Medicare, Medicaid. It also includes what are just called federal contractors. So, and this is an area, a mandate like this, where employers who receive federal funding, be it through Medicare or Medicaid, or if you're an employer that chooses to contract directly with the federal government, so you're a federal contractor, in my mind, there's no question that those mandates will be upheld. Employers who are federal contractors are subject to quite a number of executive orders. This executive order is no different. And the thought here is that if you choose to do business with the federal government or to accept Medicare, Medicaid money, these conditions sort of go along with that. So yes, that is correct.
Thanks. We have another, oh, sorry, go ahead.
I'm sorry, go ahead.
Oh,
Next
right.
question.
Regarding the weekly testing, does this need to be done at a specific location, or could an at-home test be okay?
That should be, I can't answer that because we don't have enough detail yet. That should be a question that is answered when the OSHA emergency technical standard comes out. But if you think about it and think about part of what the president said, and I'm not sure how closely anybody paid attention to this piece, but one of the things that the president said as part of this 6-part program that he introduced was that places like Walmart and Kroger and Amazon would be selling home kits at cost for a period of time, and there would be a ramp up on testing under the Defense Production Act. So it wouldn't surprise me if it could be an at-home test based on the language that the president used, but we'll know for sure when this standard comes out.
That's helpful. Another question we have here. Could employers put all who are not vaccinated together in the same shared space 6 feet apart?
That, I suppose, would be an option if you're an employer that is under the 100 standard, so that the mandate does not apply. I would say it could be an option, but it certainly would have to come with what I would describe as other protective measures, right? Depending upon your thought about that same shared space 6 feet apart, whether there's the plexiglass, whether people are masked, what the other requirements are, it might work. We need to know a little more though.
Okay, we have another question. Do EEOC vaccine exemptions apply in New York State with the HERO Act mandates?
That one I'm not going to be able to answer right off the top of my head. I'm sorry.
Okay, we can follow up on that.
Yep.
Will the vaccine mandate apply to employers who are religious organizations or nonprofits?
I don't see anything right now that it would change that, unless certainly if you're a nonprofit, it's going to apply. If you're a religious organization and you have over 100 employees, it would apply unless you were one of the religions where there's a firmly held belief that you cannot use vaccines.
Great. What time frame do you anticipate OSHA will be finalizing the ETS rules?
Sure. Based upon the reading I've done so far, we're looking at least a couple of weeks, at least. And like I said, in that time frame, we may well see a court challenge that even if the ETS rules come out, will delay the actual implementation.
What are the chances an injunction will be entered against the vaccine mandate due to numerous lawsuits they're anticipating?
Yeah, that's your guess is as good as mine. But I would say I would put, if I were making a bet right now, if I were standing at the table in Las Vegas making a bet, I would put a bet on an injunction will issue. That's where I'd put my money.
Great. You mentioned that 100 employees could be 50 here and 40 there. What are your thoughts on, say, a franchise owner who may own 24 to 25 stores with, say, 10 employees at each? Do you think this would fall in the 100 employee bucket since the company has over 100 employees?
That's a tough one. I think I would need to know more, but I would right now, if I were that employer, that franchise owner, I would plan as if this mandate's going to apply to me, and then hope that when the final regs come out that it doesn't. But I'm thinking that the president wants this to be as broad as possible. And so I'm suspecting, don't know, but I'm suspecting that the OSHA regs that come out will be broad enough to capture that scenario.
Great. We've read that as a subcontractor to a GC, we are able to release names to the GC of employees who tested positive. Are we also able to release names of those vaccinated or not vaccinated? And are we required to release those names if they ask us for that?
Yeah, so I'm not sure that where the concept of being able to release names of employees who tested positive comes from. Normally, we are advising all employers to not release the actual name, even though in many cases, by just disclosing that someone has tested positive and sort of providing the parameters of where that person had been and thus who may have been exposed, you make it anyone can really figure it out. We're not advising anyone to actually disclose names at this point. So I think the answer to that question would be no. I would not be advising folks to do that.
And one final question: for healthcare employers receiving federal funds, has a specific date been announced that we must implement the vaccine mandate?
Not yet. Not yet. That's one of the other things that we're waiting for and should be able to answer within a few weeks.
Excellent. Well, thank you, Mark. I learned a lot on this webinar today. Thank you all for attending. We hope you came away with some helpful information and strategies for preventing COVID-related lawsuits in the workplace. I also want to remind everyone that the link to the recording and the slide deck will be sent out in an email later today. And also join us next week. Check out our website. We have a full portfolio of webinars on all these really important issues. Next week, we'll be taking a deep dive into HR compliance issues around remote employees and a number of different other topics throughout the rest of the year. So thank you, Mark, and have a great rest of your day, everyone.
Thank you. Bye-bye.